Hi everybody, it's Rob Reed, and I'm introducing a new vehicle to provide legal advice to people in the state of California, particularly because I'm a California lawyer and have been for, I guess it's been nearly 23 years. I primarily practice personal injury, business law, music law, contracts, adoption and surrogacy, and I advise people on small claims cases as well, which is the brief issue we're going to talk about today. I'm hoping to do this. We're going to aim for Tuesdays at 6 o'clock, 6 p.m. every Tuesday for any questions that you might have legally. If you're from out of state, if it's a question that I can't answer, an area of law that I don't do, you go to AskLawyers.com, simple form that you fill out, and we forward it to attorneys that are in our database from throughout the world, really, but primarily the country of the United States. And if we don't find anyone, we'll try and assist you to find somebody there. If you're an attorney looking to join, there's a link that you can find once you get to the website. So if you have any questions, you can put them in the chat. I'm making sure that the chat is going to be uh, written in and I'll be able to see it. I don't expect, because there was limited advertising with this, that we're going to get any people at all, really. And that's okay. But you might have been turned on to this video by a question you might have queried about small claims court and how to handle it. It's something that I get asked often. It's an issue that I'm talking about in the #1 podcast here or videocast, because it just was a question that I was helping somebody with yesterday. In small claims court in California, and speaking in Los Angeles particularly, it's a $10,000 maximum limit. May have changed since last I heard, but that's sometime from last year was the $10,000 limit. I'm pretty sure that's what it is. And it's very much the scenario that you see on Judge Judy, those common scenarios that you see on television. And the same rules really apply. When you see people get in trouble with Judge Judy, you're probably going to be that person if you do the same things that those people had done. In particular, there's a particular pitfall that we'll talk about. It's very brief what you do, but probably the most important thing, and this is what I do for a few $100s, it's a small fee depending on the complexity of your small claims case, is you want to have an outline. And that's what I prepare for my client, is just particularly they don't need your presentation. I mean, you want to look good, you want to be clean, you want to try and enunciate and all of those good things. But if you're looking down at your notes, I think for the most part, once you're done with a particular note, explain. The truth is always your friend in these cases. Explain to the judge, based on what the outline is saying, where you are, what you want to present. Don't go off from what is there, but you want to be well prepared and well organized. And let's say a simple personal injury kind of case where you went to a store, or let's say you were an auto case that an attorney wasn't willing to take because it wasn't worth enough. You go in and you want to basically prove from the basic part, #1, why you're there, which is you wouldn't be there if you didn't have some form of damage. So you explain what happened, why the other person is at fault. Leave it at that simple. If let's say you're rear-ended, you say, I was rear-ended, Your Honor. That caused me medical bills in the amount of X, and that caused me some pain and suffering I'm claiming in the amount of Y, and I had out-of-pocket expenses for prescriptions and whatever, that's Z. And then you have all of the documents that will show that. So that's the next one, is have well-prepared evidence. You need to have documents. The burden of proof is going to be yours as you're presenting a case. The defense doesn't have to say a word. You're the one that has to say it, and you have to have good documents. So in the case example that I gave you, if you have medical bills, you want to have good copies of that, signed by the doctor. You present with a bill and hopefully a report if the doctor made one. If there's property damage that you had, you have an estimate, assuming that you didn't get it repaired. If you have it repaired, if the estimate's bigger than your repair bill, you have to be, whatever your damages are, whatever the out-of-pocket amount is. So if there was a certain amount paid, then that's what you present. Make sure the documents are clear looking. not bad copies. You want to keep your presentation super simple. It's when people go out of the issue at hand, and it happens with the person that I was giving advice to just the other day, and that's why it prompted this discussion. The person, this was a landlord-tenant dispute, but it was a personal injury one where a ceiling had caved in on a person who lived in this particular apartment, and that caused this person injuries. It wasn't substantial enough that an attorney took the case. Actually, it was an attorney. I should change that. Attorney did take the case, but they felt it wasn't substantial enough to take to Superior Court, put a lot of money into it, that it was an under $10,000 claim, and the landlord was denying it. Okay. So what the landlord did in response to all of those things was retaliatory. A retaliatory increase, and this is an argument, I'm sure the landlord would argue against what I'm saying, but this is the claim from the person who called me. The landlord made a retaliatory increase in the monthly rent. I'm pretty sure that's illegal, but I don't practice that area of law. If you're asking me a question about that, I probably wouldn't be able to tell you. I'd tell you that it sounds like it's wrong, and I think that it is. Nonetheless, it's irrelevant for the incident that happened. The incident happened was something fell, the ceiling fell on top of this person, causing him injury. When you start saying, oh yeah, Your Honor, the landlord increased my rent a few $100s, that increase of rent, while it's retaliatory and it makes the landlord look bad, that's the type of thing that gets Judge Judy nuts, because she's trying to figure out that a small claims attorney or judge that's listening to your case wants to just focus on what the issue is. So the minute you've gone from the issue, the injury, filing, negligence from the landlord, and now you're talking about something entirely different, even though it's entirely, it's a big deal. It's a retaliatory rent is a big deal, but it's not relevant to the issue at hand. So you don't want to talk about things that are outside what you are there to sue for. And unless you have a cause of action in there, in your small claims case, for retaliatory action on the part of the landlord, you don't talk about it. Only discuss the issues. Don't add anything. Follow your outline. Get an attorney if you can to prepare your outline. Someone like me you can call at the phone number that's down below. Actually, that's a different number. My number would be 818-783-7998. Probably end up putting that in this presentation later. I don't think that I have it on here. The phone number 818-527-4955 applies to it's actually my Skype, and that's how we will have a conversation when somebody calls in and has a legal question. Which reminds me, I'm not sure that I have Skype loaded, in which case that would be a good idea in case somebody was trying to call. So the number is 818-527-4955. Once again, we're all loaded up and ready to go. But to finish up on what I was talking about with small claims, again, is have an outline, get an attorney to help prepare it for you, to make sure that there's an organization to your presentation, which usually must say, why you're there, your name, why I'm here, Your Honor. Good morning, Your Honor. My name's Rob Reed. I'm here because a ceiling collapsed on my head and I was injured. That resulted in medical bills. I have an exhibit here. That resulted in broken eyeglasses. I'm making it up. Have a receipt for the new eyeglasses you had to buy. That's your damage. I had to buy over-the-counter pain medication because I had serious headaches. Here's my receipts for that, Exhibit C. And the landlord is responsible because there was a leak. I had warned them about the leak many, many times, and they did nothing about it. Thank you, Your Honor. That's like, then let the judge ask you questions, and only ask whatever the judge asks you, then you say it. The other side will give their view. That simple presentation I just made might be enough for the judge to say, okay, let me see your documents. Oh, you, defendant, do you have anything to say in your defense? And at that point, the defendant will talk. You stay as quiet as possible. You've seen it on Judge Judy all the time. As quiet as possible. Let them say what. Have a pad and notes when they have said something that may not be that may be inaccurate. Try not to say things accusatory like that they're lying, they're this, they're that. Just say your positions. You're not lying. Don't lie. Tell the truth. They say something, just say, I believe, Your Honor, that's a misunderstanding on their part, or my version of things is much different than their version. Don't call them names. Don't do stuff. It'll tick judges off. You want to keep things absolutely simple. So that's it. Not getting any calls right now, but every Tuesday, 6 p.m., I will be available here. Might have guests. I have colleagues in the category of immigration, in criminal law, in family law, a lot of other areas, and I can certainly have them on to come ask any questions that you might have. You're seeing this and it's not live. AskLawyers.com. Go there, enter your query. It's free to use. It'll send out to attorneys that are in the database. If we don't find one, then I'll see if I can find one for you, and hopefully get your question answered. Your question may be used in a future podcast, videocast. If it is, I'll email you and let you know that I'll have a guest, or I'll be the one to answer it, but I might have a guest who will answer the question for you in that area of law. And that about covers it. So thank you for watching this first installment of the AskLawyers.com free legal advice. And I thank you for watching. See you next Tuesday.